Hi there. My name is attorney Rick Gottlieb, and I've been a bankruptcy lawyer for more than 30 years now. During that time, I've also been an adjunct professor of business and consumer bankruptcy law at two separate law schools here in the Boston area, and even given seminars with other lawyers and bankruptcy judges to members of the Massachusetts State Court Judiciary as well. Now, I understand that many people, particularly those that owe money to creditors, are very, very reluctant to even consider bankruptcy as a possible option, and this is natural. Many people labor under the misconception that a bankruptcy filing is somehow more a mark of moral failure or a shortcoming of their personal character. And this misconception is reinforced in our culture that confuses a person's individual merit and value with the computer-generated credit scores issued by credit reporting agencies. Now, I know that there are ads on the internet and TV making promises of a previously undisclosed debt relief process that will either drastically reduce or eliminate your debts that seem just too good to be true. The problem is that they are just that, too good to be true, and they are nothing more than what are called debt management plans that attempt to negotiate with creditors to reduce payments, but cannot compel those creditors to accept such reduced payments, only to further erode the borrower's credit and finances, and only to later discover that they were wasting both their time and their money in the process. When people, for reasons of loss of a job, disability, illness, inattention to spending habits, or just plain bad luck, find themselves over their heads in unmanageable debts, the very first thing that they ought to consider is speaking with a legal professional that is competent in legal aspects and remedies of debt and finance. Therefore, at the outset, in this brief video, I'll give you an overview as to what bankruptcy is generally all about. First and foremost, you should understand that bankruptcy is a federal right. It's not a creature of any one of the individual states that make up our union. Although certain aspects of bankruptcy law can be influenced by state statutes and case law, bankruptcy is primarily regulated by federal statute from Congress and, in its present form, has been around since 1978, known as the Bankruptcy Code. Moreover, there are different forms, or as they're called, chapters of bankruptcy that have different features and different aspects. Now, one chapter is not better or worse than the other. They're just different, and they serve different uses and purposes that have different benefits and drawbacks. But the thing that you should know at the outset is that bankruptcy, in general, is nothing more and nothing less than a form of financial redemption for overburdened consumers and businesses. Now, for people, as opposed to corporations, limited liability companies, and certain business partnerships, there are primarily two distinct forms of bankruptcy. Chapter 7 on the one hand, Chapter 13 on the other. Chapter 7 is an asset-based form of bankruptcy. That is, what drives the distribution of money to creditors is the liquidation, turning into cash, those assets of the debtor that have a substantial value over and above encumbrances, mortgages and liens and the like, and over and above what are called exemptions. Exemptions are statutory set-asides for the debtor under either state law or applicable portions of the Bankruptcy Code, so that when the debtor exits the bankruptcy process, he's not left as a penniless ward of the state, but rather has a sufficient quantity of assets so as to have a meaningful fresh start in their financial lives. People who file for Chapter 7 relief, most people do, can do so because they can exit the bankruptcy process relatively quickly. It's typically about 4 months while they're in bankruptcy. And they'll exit the process with a discharge of debts so that they'll have, so long as they have no substantial assets or encumbrances that would cause a Chapter 7 trustee to want to liquidate them. By comparison, a Chapter 13 is an income-based form of bankruptcy. That is, what drives a distribution of money to creditors is a monthly payment to a Chapter 13 trustee who acts essentially as a distribution agent for the creditors under a court-approved Chapter 13 plan. The unsecured creditors are entitled to receive the greater of A, what they would have gotten had the case been a Chapter 7 liquidation, or B, what represents in dollar terms as the debtor's best efforts based upon his or her net income. Chapter 13 cases are typically filed by homeowners who are either behind on their mortgage, as it provides in that particular chapter a mechanism for curing that default over the life of the plan, which is typically 3 to 5 years. It can also be for people who owe money to the Internal Revenue Service or to state taxing authorities, or people whose equity in their assets exceed the exemptions that might otherwise be applicable, or if they happen to have income so large that putting them into a Chapter 7 case would draw the possibility of a motion to dismiss for what's called abuse of the provisions of Chapter 7. There are lots of nuances associated with each of these two chapters of bankruptcy, and it is therefore extremely important to find and use a competent bankruptcy attorney to guide you through what can fairly be described as a legal minefield. It is all too common that people that attempt to file a bankruptcy case by themselves in order to try and save some money will only find that they have made an incredible mess of things, losing their discharge and potentially placing their assets at risk. Additionally, even using a lawyer with a generalized legal practice, one that's not focused on bankruptcy law, is also unwise because major changes to the bankruptcy laws, bankruptcy rules, forms, even to bankruptcy practice change all of the time and require day-to-day diligence in order to stay on top of all of these changes. Now, I hope you have found this video, all brief though it may be, to be informative. And if you have any questions about your specific situation, please feel free to contact me. I look forward to hearing from you. Have a really good day. Bye-bye.